First, let me say that I feel very disappointed, but also very excited. Very disappointed in the works of the Supreme Court, and also at the same time very excited about what has happened. The Supreme Court, after all, could have given its judgment and the detailed judgments. It had to take the minority's refusal to approve or reject the Chief Justice nominee before the Supreme Court would then go and sit down and give a detailed reasoning of why they made such ruling against Kwesi. I think that it is unfortunate, though, that it had to take pressure from the minority political side in Parliament to get our Supreme Court to do what they ought to have done long time ago. I have said time without number, and let me repeat it, that the case of Judge Kwesi smacks of travesty of justice. It does not bode well with me in any common sense reasoning, because in the case of Judge Kwesi, he was not the only MP whose constituency was under contest or under litigation. There were several others, from Savulugu to Zabzugu to Jomoro to Techiman South to Asen North. There were about 6 or 7 cases that were in court. And the courts never said that they should stop carrying themselves as MPs. The courts never said they should stop carrying themselves as MPs. They carried themselves as MPs until the final determination of the issues. And I also recalled in 1995 rather, there was the case of George Amo and Rebecca Adote. That case traveled. For the period that it traveled, Rebecca Adote was a member of parliament for Ayawaso West Wogon. It was not until the courts determined that by the votes and by every count, George Amo would have won that election, that the court then ordered that George Amo should be paid the full entitlement of a member of parliament. But I did not see that they requested for the return of all the entitlements that Rebecca Adote had received. But they asked that George Amo, who did not serve his term, should be recognized as the member of parliament for Ayawaso West Wogon. In instances like this, where we are told that precedents are used as one of the hallmarks of making judgment, it is obvious that the courts never stopped the person from carrying and conducting himself as a member of parliament. Justice Kwesi was given a raw deal, where he was prevented from performing his lawful duties as a member of parliament. And you would think that this was a deliberate political orchestration that probably found favor with the judiciary, because from day one, when they entered into the chamber, they started these attempts to get Judge Kwesi out of parliament. He was almost prevented from participating in the opening session of parliament. And so I am very disappointed that our laws, and I say this all the time, that it appears that the judiciary is becoming complicit in the executive crimes. And anytime the executive wants to do something and they cannot get it done, they will simply run to the courts. And somehow, and in most cases, they get the favor of the court.
But is it not true that the Supreme Court is clothed with that power of interpretation of the Constitution each time each article of the Constitution or clause should come under any level of disagreement or disputes? Or
I will not engage, because I'm not a lawyer.
Great.
But all that I want to say is that before law, there was common sense.
But law is not always common sense.
Well,
law is what it is.
If you take common sense away from law, I'm not sure that law will exist. And so it must be applied. Law cannot be run on its own legs. In fact, it is common sense that informed the law, right? So where I sit, I think that it is important to look at it from two perspectives. One, when you read the Constitution clearly, it's talking about allegiance.
Yes.
Right?
Yes,
it's talking about allegiance. And the question I ask
in
is...
9-2.
It's talking about allegiance and not about the duality of your citizenship. So if it's talking about allegiance, Kwasi Tesin has properties in Ghana, right? He was born a Ghanaian. By economic favor or some work reasons, he decided to become a Canadian citizen. In spite of that, he had come to Ghana repeatedly. He has his investments. He has everything in Ghana. He decides to come and contest elections. And it is not oblivious to the Supreme Court and to our courts that at the time the man filed for the renunciation of his citizenship, the Canadian citizenship, that soon after that there was COVID. And COVID stalled a number of programs. So it took a longer period for him to get the renunciation certificate. Is this one too difficult for the courts to appreciate? Was our court working in full session when COVID was in place? Many judgments that our courts in Ghana could have passed because of COVID, they did not. Right? So this one, you are saying that you throw away the common sense aspect and go and say you are going to follow the rigidity of laws. So when it was obvious that, look, the man has submitted, and by the terms, he was supposed to get his renunciation certificate within a certain period. But because of COVID, he was unable to get it. And it is not that he did not make preparations. Before the elections, the renunciation certificate had come. Don't you put the, what do we call it, the mental attitude of the person? What steps did the person take? It's like even the Electoral Commission. And Motala, you know this very well, that you are required to bring your tax clearance certificate.
Yeah.
No, so. Yeah. But if you are not able to give them a tax clearance certificate, you have to show proof that you have taken steps to obtain the tax clearance certificate. It's as simple as that. Yeah. You have to show proof that you have taken steps. And the Ghana Revenue Authority acknowledges that you have taken steps. And then they will give you. Then you go and file your contestation. It is not everybody that has been able to get a tax clearance certificate, even though it's a requirement for you to be eligible to contest. And so the arguments here say that he was unable to obtain his certificate. And I find that a bit preposterous because certainly he had taken all the necessary steps. And it's like when you submit your application that I want to do my citizenship to be discontinued, from that day you cease to be a citizen of that country until otherwise. Because I decided to become a citizen, and I am saying that I don't want to become a citizen again. You cannot stop me from wanting to become a citizen or not wanting to become a citizen. So I feel that the Supreme Court has sometimes been unnecessarily harshed. There are instances where people have not taken any steps to renounce their citizenship. And therefore, you could say that because you did not take any steps, you are incompetent to hold office as it is now. But somebody that has taken all the necessary steps, and you are very much aware that it was just left with the paper to qualify the person and say, no, I will not do so. I feel that is unfair. Today, by the time you made the ruling, the man is officially qualified to contest elections. His party is refiling him as the candidate. And by the analysis that we are doing, if the PNC is unable to file a candidate, he may probably win. And he comes back and he's readmitted into the House as a member of Parliament. I think that is certainly not right. Finally, let me say that let's not believe in the rigidity of our laws. As we say, law is made for man and not man for the law.
Well, and